Hello and welcome to the third dot point of the LOLhsc legal studies tutorials, and today we're going to be going through the dot point define, summary and indictable offences. Now, despite it saying only define, summary, indictable offences, there's two parts you need to cover in this dot point. Not only the summary and indictable offences but also parties to a crime. We'll start with the summary and indictable offences. Now, summary, as you can see with the dot points here, are concerned with the less serious offences. There is a maximum penalty of 2 years imprisonment, and this all comes under the Summary Offences Act 1988, New South Wales. So if you have any essay that relates to summary or indictable offences, mention that legislation. It'll be key for you. And also a big part is that it is tried by magistrate in the local court. Now, it's like, if you need some examples of what summary offences are, it includes stuff like minor theft, vandalism, and if you need more of those, just look up the Act and have a look underneath that. So, and then comparatively, we have indictable. Indictable is the more serious offences. So this is stuff like breaking and entering and like murder. What happens in this? It's very different compared to trial by magistrate. You'll go to the local court. They're charged there. They have a prima facie hearing. Prima facie is a Latin term for something, or what is known as something, pretty much showing the evidence to see if there's enough to suffice having the actual trial. If there is, say there is, it will then move into the next court, such as the district, or if it's a young offender, like the young offenders court, depending on what the actual issue is. Then they'll be tried by a judge or a judge in duty. So that's the main differences. If you need to write down the dot points there, it's very easy. Summary is less serious. Then we have max 2 years imprisonment, Summary Offences Act 1988, and trial by magistrate. Then indictable, more serious, and it involves a prima facie hearing to show if there is enough evidence for trial, and then they move on. So that's the parties to the crime. The question you've got to ask yourself is, what are the parties to a crime? And this came up in the 2012 HSC multiple choice, so it's a very, very important one. The law will distinguish the various roles of people in a crime, and they're the four listed there. We have principal in the first degree, principal in the second degree, accessory before the fact, and accessory after the fact. Now, principal is in the first degree is the actual perpetrator committing the crime. So if it's a murder, for example, it's the person committing the murder. Now, I've written first with the numbers, but in an essay, right, with the FIRST, the actual first. Principal in the second degree is the person who was present and assisted the principal in the first degree in assisting. So that'd be like, say, again, I come back to the murder. It's a very easy example. It'd be a person who, say, who tied up the person and the other person came and killed them. Then we have accessory before the fact. Pretty much it's someone who does anything that assists in the crime happening before the crime actually occurs, such as planning it, like going in and scouting out the location, say if it's a bank robbery, looking at security cameras, stuff like that. And then the final one we have is accessory after the fact, and that's someone who knows about the crime and helps them afterwards. A very good example of this is Avi Nikita Iskander in 2012, where she helped her son flee a strange jurisdiction after killing the mother's lover. Now, for any of these accessories, what needs to be proved, if you go back to the second dot point, the second dot point, the first dot point is mens rea. They have to, the prosecution has to prove that they knew that the crime had been committed, because the actual act of just helping them, unknowing that they were, if the mother didn't know that he was fleeing a strange jurisdiction for killing the mother's lover, which is a poor example, but I'll give that example anyway, then she wouldn't be charged. But because she knew the son had killed the mother's lover and then helped him, then she could be charged with accessory after the fact. And yeah, so to sum that up, you're just going to know what are the summary and indictable offences, what are the main differences, any legislation, and then you need to go to what parties to a crime, the four parties of a crime, and this case study here is a very good one if it comes up in a 15-mark essay question. I hope that helped, and thank you.